This is the Hidden Killers Podcast with Tony Brueski.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
What's Gull got? That's the question when we're talking about the case against Delphi murder suspect Richard Allen. The judge in the case, Judge Gull, this week entering an order correcting some of her previous mistakes or errors with regards to defense filings, but still, as of this moment, has not reinstated Richard Allen's attorneys. Here to discuss what these orders mean, Bob Motta, defense attorney, host of the podcast Defense Diaries. What's been the latest this week with Delphi and Judge Gull?
Oh, Tony, it's just the case that never sleeps, man. It's like the case that never sleeps. Every time I try to do something else, like, I'm doing this Avery deep dive.
Yeah.
Every time I think I'm out, they pull me back in. Yeah, still, more action. Like you said, kind of leading into this week, Gull ends up, as you aptly noted, she finally drafts an order, which essentially instructs the clerk to do everything that they were asking for in the writ for the writ for mandamus. So, that because there was two of those that were filed. We had the first writ that was basically saying, okay, your docket's all screwed up. There's tons of documents that you didn't put on there that should be put on there. There's documents that were on there that you took off, blah, blah, blah. So she then, knowing that she's got this due date of the 16th, which was yesterday, to get her written response on file on the 14th, she ends up filing that order, which effectively moots, and that's M-O-O-T, not M-U-T-E, moots out or kind of voids out or makes it irrelevant, the writ for the mandamus, because she's essentially doing what they're asking the high court to make her to do. So at that point, she, there's one interesting thing in there in terms of that order. So she goes ahead and she orders that the 118 documents that they had created that weird website for, that was actually very difficult to get into those documents. And as it was stated in the writ, none of them are in the petition. None of them were clearly marked what they were. So you literally had to go through and open everything individually. Didn't show you when things were filed, so there were a lot of problems with it. And frankly, it just wasn't easy to navigate. If you're like an old man like me, who's somewhat tech challenged, it was difficult, So basically she says, all right, get those all on the CCS, which is the actual docketing system. And then as far as, the two other things with this sheriff's, they were terming it an affidavit, but it's not really an affidavit. It's kind of like a report written by the sheriff in regards to this inmate that they were going to be transferring, who had been subpoenaed to come testify at that June hearing about getting Allen transferred out of Westville prison. And essentially this guy Baston had written this long letter saying, look, they've been torturing me. And I'm paraphrasing, obviously, he goes into great detail, but, they've been torturing me here, breaking his ankles, stabbing him with pens, not treating him for the injuries, soaking his mattress in urine, everything imaginable that you can imagine being done to you in a prison, they're doing to this guy. And, but he also articulates that they're doing a lot of the same things, but physically and mentally torturing Richard Allen as well, which was the reason that they were going to try to bring him in to have him testify. And he's basically saying in this letter, look, I'm afraid to come testify because I feel if I do come testify, that what's going on now, which is already horrible, is going to get worse. So he's basically writing a letter to the judge saying, look, thanks, but no thanks. I'm trying to stay alive here. And I feel like if I come testify, that may not be the case, so that's essentially going on. So she's now, what she had originally sealed those, which is interesting. I don't understand why she ever would have sealed that letter. Should have been open and obvious for everybody to see. And you know that when that letter comes right around the time when this hearing's taking place, it makes it seem nefarious. Now, whether it was her intent for it to seem that way or not, but when the subject matter of that hearing is to get Richard Allen out of there for reasons that they're claiming are similar to what's going on with this guy, and then she decides, instead of allowing the defense to see it, which I don't know if they saw it or not, but the public certainly didn't see it. It just makes it seem shady.
Yeah.
Like, this guy's complaining of all the things that the defense is coming in here and complaining about with respect to Allen. And now she's like filing this thing under cover of darkness. It's like all these little things are the things that make you wonder what Gull is doing. Like, what is her motivation behind doing this stuff? Like, I don't think that Judge Gull is in cahoots with anybody to screw Richard Allen, at least objectively.
Mm-hmm.
Do I think that she has zero regard for this guy's constitutional rights? Absolutely.
Yeah.
And what she's doing in terms of how she's handling this case is my proof of it. I don't have to be a mind reader to see that she has very little regard for his constitutional rights. So ultimately, she files that order a couple of days later. Yesterday, to me, a matter of fact, she drops her response. Response, frankly, is well written. It was defended properly. I think that they make strong arguments. I think that on the technical side of it, she's correct in the sense that this should have been brought to the lower court prior to and had their motion denied by the lower court before they motioned it up to the high court.
Sure.
But when you read the original petition, they acknowledge that is typically what's supposed to happen. So they acknowledge that they skipped a step early on, and I'm talking about the relator, Richard Allen and his lawyers. They knew that they skipped that critical step in terms of being able to go up to the high court. But then they tried to say, well, this is why we did it. There was extraordinary circumstances and these are what they are. And this is why we had to skip that step. Whether or not the Supreme Court's going to find that to be compelling enough for them to agree with Richard Allen and his attorney is yet to be seen. The bottom line is, however, that it's not going to matter because she cured a vast majority of the issues. Okay, so like all the docket stuff, she basically, number one, threw the clerk under the bus. So that she had a couple of moves. She had the move of, all right, they didn't follow the rules. So just without even getting into the merits of it, like the Supreme Court should just reject it because they didn't follow the rules. So just as a technical violation of the rules, they shouldn't even get to the merits of it. If you get to the merits of it, you can't blame me because the CCS is the clerk's responsibility alone. I have no responsibility over the docket. So that's her argument as to that. I reject that because when you look at these gaping holes, I think she's right on the technical side of it. And if the court doesn't find that there was extraordinary circumstances or that, these are issues that could not be handled on appeal after conviction, that this is the only way for them to get it done. If the court, doesn't buy that, then it gets rejected on those reasons. Never get to the merit stuff. But if they do get to the merit stuff, I think she makes a weak argument there. I just don't think the clerk is not responsible for preparing court orders, meaning drafting it, making a ruling, and then signing it. That is the judge. So when there's gaping holes in terms of court dates that have taken place and there's no order drafted, it's not the responsibility, or is it even in the purview? The clerk cannot write court orders and sign them. It's not their role.
Yeah.
That can only be done by the judge. So those gaping holes in the docket are going to fall at the feet of the judge ultimately. But like I said, I mean, the judge is smart enough to know that this is how they were going to play it. They know that the much bigger fight is the upcoming petition, which is clearly a way, way more serious set of circumstances because it really involves the nuts and bolts of the case. They're trying to get his attorneys reinstated. They're trying to get her pulled off the case. And they're obviously trying to stay or delay everything that's going on at the trial level. So, that's where the real fight is. And I think that she realized, okay, look, I'm going to fix everything ahead of time. We'll still prepare the response for this first one. But, I don't want to go into the second one having lost the first one.
Sure.
So I think that she made the curative actions. I think she made the strong technical argument. I think she made the much weaker argument. And then the thing that stuck with me the most in both her order, where she related back to the memo, the controversial 136-page memo, where she says, look, okay, like subsequent counsel, or I'm sorry, successor counsel has the ability to be able to adopt the memo and ask for the Franks hearing, which I will schedule. Or if they don't, then I won't, and she basically doesn't give, but she also instructs new counsel that if they do adopt it, that they have to redact it. So I read that court order. I'm like, redact what? I'm like, the thing's out there. Like, it's like she's trying to act like the thing doesn't exist in the world and we haven't all seen it and that it's not out there. It's like, what is the point of a redaction when the cat's already out of the bag?
Yeah.
You know what I mean? So then when you kind of get to her response, she clarifies and she gets to the specifics. She's saying, I made these confidential because the defense filed this and had not redacted the victims' names.
Okay.
Now, I've been searching in Indiana law. There are certainly circumstances, especially when you've got victims that are not deceased, but are still living, that are juvenile. They'll oftentimes just use their initials or will completely redact the names altogether in order to protect their identity because they're still alive.
Sure.
They want to, but in a unfortunate situation where you've got victims that are deceased, you're not necessarily concerned about their privacy rights because they're not alive to have privacy rights. So that argument kind of falls on deaf ears. And I'm on top of that, I'm going back searching through the state's filings, and I see at least 2 filings where the state themselves had used both the girls' names, full names, and they weren't redacted, and she didn't make those confidential. So, there's just like constant weird stuff going on with it.
Yeah.
And, I just want this thing to get straightened out.
Yeah. I mean,
so we can have a fair trial, man.
Sick of the ads?
We are too.
Start listening with no commercials now and get access to all of our episodes in advance of everyone else.
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
Search True Crime Today Premium Plus on Apple Podcasts or go to our podcast page and sign up now.
True Crime Today Premium Plus.
Sign up now.